The Fourth Amendment protects against unreasonable searches and seizures. Now, in order to determine if your constitutional rights have been violated, we need to understand when does the police seize a person. In this case, we answer the question if shining a flashlight and telling an individual, hold on a second, means that the officer seized that individual. The case is United States versus Hood. And here we're dealing with GRU, which is a gun recovery unit. These are officers that drive in undercover vehicles. They usually drive in tandem, and they try to recover illegal firearms in the District of Columbia area. The facts of this case are pretty simple. Two GRU units that are undercover police vehicles are rolling down Residential Street. Same time, Mr. Hood is walking down the street towards his own house. One of the units pulls over, the agent walks out, shines a flashlight at Mr. Hood, and tells him, hold on a sec. Immediately, Mr. Hood raises his hands in the air and stops. Now, at this point, the agents never activated their lights on top of the vehicle or made any siren noise. The police officer then starts approaching Mr. Hood. As Mr. Hood slowly backs away from the agent. The agent then notices that there's a big bulge in front of Mr. Hood's pants. So he asks him, what's that bulge? Mr. Hood answers that he doesn't want to consent to a search. The agent then replies that he's not asking for consent to search him and instead just wants to know what it is. Mr. Hood refuses to answer and continues to say that all he wants to do is go back to his house and he doesn't want to answer any questions. So that goes back and forth until the agent eventually gets close enough to Mr. Hood. He detains him, puts him in handcuffs, they search Mr. Hood, and they find a Glock pistol in his waistband. Mr. Hood gets charged with possession of illegal firearms. And of course, the question becomes, was he seized? Because the Fourth Amendment protects you against unreasonable searches and seizures. That means if the seizure was unconstitutional, then all the items derived from that illegal seizure must be suppressed. This is known as fruits of the poisonous tree doctrine. Now, if the seizure was constitutional, then of course all of that evidence stays in trial against Mr. Hood. A person is seized by the police if his liberty is restrained, and that can happen in two ways. He can be physically restrained or by show of authority. And when we say show of authority, we look at the number of officers, we look at if the officers are armed, if they're wearing a uniform, the time of day, if the officers are using the language and tone that takes control over the person, or if they make any threats, if they show their firearms, or if the firearms are drawn and the individual can see them. That's what we mean when we say show of authority. And the question in this case really deals with that part of seizure. Since nobody has ever stopped Mr. Hood from walking away, it was really the first officer that told him that he's not free to leave, potentially by saying, hold on a second. So then the question becomes, did that become a seizure? Mr. Hood argues that the seizure started from the moment the officer came out of his vehicle and told Mr. Hood, hold on a second. Now, the government makes an argument that the seizure happens a few seconds later when the officer tells Mr. Hood to stop backing away. Now, why are those couple seconds are so important for this case? Because if we agree with the defendant, that means that there was no reasonable suspicion to stop or prolong the search of this individual. Now, if we agree with the government, that means that the officer already saw the bulge and there was probably some reasonable suspicion to investigate and figure out what did Mr. Hood have in his pants. The court agrees with Mr. Hood because hold on a second was not a question but a command. It sounded like a statement. And the officers were in an unmarked vehicle. It was late at night. There were two of them, and they both were armed. A reasonable person would think that compliance was required. It was not an option for him to walk away from these officers. And for that reason, the court says that, hold on a sec, was the moment the seizure began. Thus, the firearm that was seized as a result of this stop must be suppressed and thrown out as evidence from trial. If you enjoyed this video, click like, subscribe, hit the bell notification button so next time I post, you'll be first to know. I also have some merch on my website at lostash.com/merch.